Good morning, friends. My today's topic is relief of suspension of sentence and bail pending appeal can be granted even if the convict has not undergone half of the sentence. So, friends, Honorable Supreme Court said yes, relief of suspension of sentence and bail pending appeal can be granted even if the convict has not undergone half of the sentence. Honorable Supreme Court was considering an appeal against an order granting relief of suspension of sentence and bail to the accused booked under the NPC. NDPS Act. This is latest finding, so be attentive to listen it carefully. Honorable Supreme Court held that there cannot be a thumb rule that convict cannot be released on bail pending an appeal against conviction unless he has undergone half of the substantive sentence. Honorable Court was considering an appeal against an order granting relief of suspension of sentence and bail to the accused pending the appeal against the conviction. The bench comprises of Justice Abe S. Oka and Justice Juby. And in this case, they asserted that in the case of fixed term sentences, if the court started adopting a rigid approach in a large number of cases till the appeal reaches the stage of the final hearing, the accused would undergo the entire sentence. This will be the violative of rights of the accused under Article 21 of the Constitution. Moreover, it will defeat the right of appeal. And additional Solicitor General S.V. Raju represented the appellant, while Advocate on record Akshay Verma represented the respondent. Now, let us dive into the factual background. The respondent was convicted for an offense punishable under the NDPS Act. The substantive sentence of the respondent is 10 years of rigorous imprisonment. On appeal, the High Court noted that the respondent has undergone incarnation for a period of 4.5 years out of the fixed term sentence of 10 years. As the appeal was not likely to be heard before the completion of sentence, the High Court granted relief of suspension of sentence and bail to the respondent. Referring to the judgment of the Apex Court in the Supreme Court Legal Aid Committee representing under-trial prisoners versus Union of India and others, that is of 1994, which was relied upon by the ASG, the bench explained that while dealing with an extraordinary situation arising out of the long incarnation of under-trial prisoner, the court therein had directed that in certain cases the prisoner shall be released on bail after they complete a certain period of imprisonment. The direction issued were by way of one-time measure. The judgment of this court cannot be read to mean that the powers of the court to grant bail has been curtailed. This was clarified by the honorable bench. And honorable bench further held that, in our view, if a case is made out for grant of suspension of sentence and or bail in deserving cases on merit, the court is not powerless to grant relief of suspension of sentence and bail pending an appeal, even if the accused has not undergone half of the sentence. Now, coming to the provision of the NDPS Act, the court explained that appellate court is bound by custody of Section 37 of the NDPS Act while considering the prayer for grant of bail during the pendency of appeal. However, if in the fact of the case, the accused has undergone a substantial part of the substantive sentence and considering the pending of criminal appeal, his appeal is not likely to be heard before the accused undergoes the entire sentence, The appellate court can exercise the power of releasing the accused on bail pending the appeal. If the relief of bail is denied in such a factual situation only on the ground of Section 37 of the NDPSA Act, it will amount to the violation of the rights of the accused under Article 21 of the Constitution of India. This was observed by the Supreme Court. Now, on the facts of the case, the bench noticed that the appeal preferred by the respondent is not likely to be heard before he undergoes the entire sentence, and he has already undergone a substantial part of his 10-year sentence, thus finding no reason to interfere with the impugned order. The bench dismissed the appeal and ordered. However, if the respondent misuses the liberty granted to him under the impugned order, the appellant can always apply for cancellation of bail. For friends, you might be interested in going to the full details of the case. So I am giving you the case title, that is Narcotic Control Bureau versus Lakhvinder Singh. You can go to neutral citation, that is 2025 INSC 190. This is all about in this case. So be connected with me to know more about further cases relating to legal matters. God bless you all. See you again.